Hello and welcome to Federal Circuit Filings 201, Appeals from the PTAB, hosted by Virtual Patent Gateway and led by Kevin McNish. Virtual Patent Gateway founder Ashley Chung has a passion for supporting women in the workplace and is committed to developing a growth mindset within VPG. A registered patent attorney, Kevin McNish represents clients in inter partes reviews, IPRs, post-grant reviews, PGRs, ex parte reexaminations, and other proceedings in the United States Patent and Trademark Office. He is currently the managing member of McNish PLLC. This webinar will be recorded for future use, and there will be a short Q&A at the end of the presentation. And with that, I'll hand it over to Kevin.
Thanks, Caitlin. And as Caitlin mentioned, my name is Kevin McNish. I am a patent attorney that focuses my practice on post-grant proceedings at the Patent Office and related Federal Circuit appeals. Today's presentation will focus principally on the Federal Circuit appeals side of that practice. Federal Circuit appeals of PTAB proceedings can include some fairly tricky procedural, logistical, administrative issues. These are things you're going to want to tackle in advance. They are things you are not going to want to have to learn how to do for the first time in conducting an appeal on the fly. And it's often very helpful to have background on how to actually do the things how to actually, file the things and how to do all the other things that you've been working hard to prepare in conducting your appeal at the Federal Circuit. So today's presentation will focus on the trickier stuff. This is the 201 course, and it presumes some basic background knowledge of Federal Circuit filings, the basic process of a Federal Circuit appeal, and some of the basics of the Federal Circuit's filing system, CM-ECF. If you want a further grounding in the basics, a recording of my Federal Circuit 101 webinar is available at the Presentations and Publications at www.mcnishpllc.com. Go to the Firm Resources menu, click down to Presentations and Publications, and you'll see the Federal Circuit 101 webinar recording. And my slides are also available from that as well, in case you're looking for a guide that doesn't involve hearing the dulcet tones of my voice for an hour. But you really do get more from hearing my voice, I'd like to think. That covers the basics. Today, we're going to be covering the trickier stuff, the more advanced stuff. And the topics are going to include correcting filings, handling confidential materials, which I could probably devote an hour to by itself, but we're going to get through it today in less than that. Citations of supplemental authority. These are basically things you file to draw to the court's attention, cases decided after you filed all your briefs. What you should do to litigate after the panel decision, and that includes things like going for rehearing by the panel or en banc, staying the mandate, which is of particular importance sometimes for patent owners, and filing just the bare rudiments of a petition for certiorari at the Supreme Court. We'll also cover some miscellaneous topics that didn't necessarily fit anywhere else. Those will include how to conduct consolidated appeals, which are appeals that involve multiple proceedings rolled up into one appeal, and separately how to cover constitutional litigation, because some constitutional issues do arise from patent trial and appeal board proceedings. And finally, the sort of special case of what to do when multiple briefs in related appeals are raising the same issue. Often this involves constitutional litigation as well, but there are sometimes situations where there are multiple appeals involving the same patents, the same prior art reference, where you're duplicating a section of a brief across multiple briefs. So we'll start with correcting filings. And as step 0 in the process of correcting filings and learning how to correct filings are some of my techniques for avoiding the need to correct filings in the first place. One of my most favorite tactics for avoiding that is to systematize a pre-flight checklist. And essentially, this is a list of tasks that I must perform before filing a brief. The brief is not done and it's not ready for filing unless I have gone through each part of my pre-flight checklist. I've checked everything off, I've finalized everything, and then I'm actually ready to file. This pre-flight checklist is a partial one of what I use for briefs. Of course, there are other things you need to do like proofreading and site checking that are absolutely critical. But this list covers some very common errors that may prompt the Federal Circuit to ask you to correct your briefs. One of the biggest ones is getting the caption on the cover page right. You need to have your caption match exactly the caption that the Federal Circuit has listed in the official caption in PACER, which is accessible by looking up your case in PACER, the electronic record system for the Federal Circuit. The next thing you need to ask yourself, are all of the required components in your brief or in your motion or in your other paper you're filing? Do you have all the required certificates? That's a big one: certificate of interest, certificate of type volume compliance, certificate of typeface compliance. Making sure you've got all your certificates, making sure you've got your jurisdictional statement. Go through the checklist of that, and there's a fuller checklist of this in my slides for the 101 presentation for when you're dealing with principal briefs as well as motions. And finally, are all of your appendix citations in the right format? This is something that also tends to get briefs bounced, and just remember, your citation is APPX and then a number, and then in parentheses an optional pin site. There's some strict formatting rules on citations, the appendix. These are also covered in my 101 presentation. But these are really kind of the top 5 things that tend to get briefs bounced at the Federal Circuit, and you would likely need to file a corrected one. Turning to the next slide, for the joint appendix, again, very similar. Is the caption on the cover page accurate? Do you have each volume numbered and labeled correctly? If you have a multi-volume appendix, you need to indicate in the top header, what number volume it is in Roman numerals and what pages it spans in appendix citations. Does each volume have a full table of contents for the entire appendix? So in other words, if you have a multi-volume appendix, you have to have the table of contents for the full appendix at the beginning of each volume, not just the materials that are in that volume of the appendix. And finally, do the Bates numbers overlap any of the contents of the documents? And so often this happens when you've got a file history or a deposition transcript in the appendix, and you've assigned Bates numbers and they overlap the, maybe something in the footer and it obscures the appendix number. Make sure when you're, preparing the final appendix, if you use Adobe, which is what I use, or a similar PDF manager, that you are shrinking the content so that the footer with the appendix Bates number is not overlapping any of the content. So the reason we have these pre-flight checklists and the reason I use these is the Federal Circuit, more so than most other appellate courts, has a reputation for demanding strict adherence to its formatting rules and to its procedural rules. You will often see things that look like relatively small infractions nonetheless prompt a notice of correction required or a notice of noncompliance, and that will in turn require you to make a corrected filing. So there's 2 kinds of notices that you may get if the Federal Circuit has some kind of issue with your filing. The first one is a clerk's office quality control message for informational purposes only. This one basically says, there's something wrong with what you filed. You don't need to correct it because it's pretty minor, but you do need to get it right next time. And if you get one of those, just accept it. You may think it's small, you may think it's unimportant, but it's important. Make sure for future filings, you're filing things correctly. Separately, you may also have a notice of non-compliance entered. And at that point, if you get one of those, you do need to make a corrected filing. Usually the court order will state the deadline by which you need to make the corrected filing. If you don't see one, the default is usually 5 business days. And if you get a notice of non-compliance, don't complain about it. Don't try to litigate it. Just fix it and move on. The Federal Circuit's, forgiving of these kinds of things, even though it is, pretty, can be sticklers about compliance. But again, it's forgiving, it's easy to correct things, so just do it. So if you are ordered to correct something at the Federal Circuit, there are some rules that govern the corrected filing. One of the things you'll need to do, obviously, is correct the document. The next thing you need to do is label the title of the document or the cover of the document with the word corrected. And here, this is a corrected opening brief that I had filed in a previous appeal. You file it the same way you would file the original document. You'll need to indicate that it is a corrected filing. And in a fairly recent rule change, if there is a correction ordered by the court or by the clerk of court, you actually don't need to file a notice of correction. In the past, all corrections required a separate notice of correction. Now, if it's required by the court or the clerk of court, you actually don't need to file a separate notice of correction. If you want to know what a notice of correction looks like, and this is for correcting filings other than by court order, here's an example. This was done under the old rules where a notice of correction was required for every filing. But as you can see, this example notice of correction shows the nature of the corrections you're allowed to make. It's non-substantive, and as you can see here, it was fixing the caption and fixing a typo in a case citation to the proceeding at the PTAB, and fixing another case citation. A comma was omitted from a citation to a particular Federal Circuit case in the brief. Non-substantive corrections are all you're allowed to do unless you obtain leave of court. And when you file your notice of correction, you need to remember to include your required certificates, including your certificate of interest and your certificate of service. Now, to file a notice of correction in CM-ECF, the Federal Circuit's electronic filing system, it's a fairly straightforward process. First, after you've logged in, you'll go to the Filing tab, select Notice of Correction, select the appeal number you'll be filing it in. On the next screen, select under the Letters and Notices menu the Notice of Correction event. On the screen after that, you will be prompted to identify the item that you're correcting. And this is the item that you're correcting, not the as corrected item. So if you filed, for instance, a brief that you need to correct, state that you are correcting the original brief, not the as corrected brief. And this is a separate filing from the corrected brief itself. This is an entirely separate paper that you need to file. On the screen after that, after you've identified the item you're correcting and the party on whose behalf you're making this filing, select the appropriate service method. Typically, that's just email via ECF. Review the docket text, perform your final review, and click the submit button, and it's filed. And that should be the end of it. Hopefully you've performed all the corrections you need to do. If not, sometimes the Federal Circuit will give you another chance to correct it, but you don't want to be in that situation. If you can avoid it, just be diligent, be thorough, make the corrections you need to make the first time around. So the next topic we're going to discuss is how to handle confidential materials in Federal Circuit appeals. I want to preface this discussion by stating this is a difficult process. It is a time-consuming process, but I want to put out there it's difficult and time-consuming for a reason at the Federal Circuit. And the reason is that the Federal Circuit's subject matter jurisdiction is inflected with the public interest to a greater degree than any of the other appellate courts. Even a private dispute between two parties over a patent case involves the public interest because patents by their nature are, carry with them a public interest. There's a public interest in the patentability of patent claims and having that adjudicated. So, the public wants to know, has an interest in knowing about how these things are litigated. And the same is true for the other subject matter of the Federal Circuit's docket, veterans appeals, Merit Systems Protection Board, government contracts. All of these things, to an unusual degree, certainly compared to the subject matter of the regional circuits, has an unusual degree of public interest in these proceedings. And that's why I think, and again, these are purely my views and not those of anyone else. This is why it's difficult to do this at the Federal Circuit. It's a public interest, and it's not because of any desire to make your life difficult for the sake of making it difficult. All of that is to say, you need to give yourself extra time when handling confidential materials during Federal Circuit appeals, because there are some additional tasks you need to perform, and you don't want to be finding out that you need to perform those tasks, after business hours, the night before a filing, or the night a filing is due. In fact, the process for handling confidential materials in Federal Circuit appeals of PTAB proceedings begins at the PTAB itself with a process called preserving the record. After that, there's some additional steps you'll need to take with making your initial appendix designations. There are some special procedures for handling briefs or other papers that cite confidential materials. There's some additional procedures for the final joint appendix, and then there is a separate certification that you'll need to perform at the end of that process, concurrently with your filing of the final joint appendix, that the parties have reviewed the materials to be included in the final appendix and have determined that material either needs to continue to be protected or no longer needs protection. Start this process early. As you can see, there are extra steps at every step of the process. Be diligent, give yourself extra time, and you will be in good shape. So the first part of handling confidential materials at the Patent Trial and Appeal Board involves what's called preserving the record. Usually in the board's final written decision, the board will enter an order preserving the record of the proceeding pending the appeal. By default, the board makes public after 45 days any material it relies on in its final written decision. I'm sorry, it may be 90 days, but by default, it will eventually make it public, and parties can request expungement of materials that aren't relied on in the board's final written decision. Now, if you're taking an appeal of that, you actually need to do what's called preserve that record, which maintains its confidentiality pending appeals. Usually a final written decision will include an order preserving the record, but not always. This panel in this particular case, this is one of my old cases, did enter an order preserving the record about maintaining materials under seal pending appeal, but doesn't always happen. So as part of your review of the final written decision, if you've had confidential materials at the PTAB, check to see whether the order also preserves the record pending appeal. If it doesn't, before you file your notice of appeal, you need to ask the board to preserve the record pending your appeal. And that goes through the typical, request for authorization and motion practice that is typically involved at the PTAB. Usually a formal motion isn't actually required, but you still need to go through the steps as if you were filing a motion, which is to say, meet and confer with opposing counsel, explain the relief you're going to be requesting to them, discuss it with them first, email the PTAB to request preservation of the record or authorization to file a motion to preserve the record, and give some times you're available for a conference call. Like I said, more often than not, the PTAB will enter an order preserving the record in its final written decision, but if it doesn't, you need to make sure that there is an order before you file your notice of appeal and divest the PTAB of jurisdiction over the underlying proceeding. So the next step, once you have filed your notice of appeal, eventually you will need to put together a working appendix if you are the appellant. The working appendix should include both the sealed and the public redacted versions of any materials filed at the Patent Trial and Appeal Board. My recommendation is to keep public redacted versions of sealed materials adjacent to them in the working appendix. So for instance, if a public version of your patent owner response or I'm sorry, if the sealed version of your patent response, occupies, let's say, pages, appendix pages 400 to 475, then the public redacted version should be immediately after that, start on appendix 476. Keep things together, do the same thing for exhibits. If there's public redacted versions of exhibits, it will help you in the long run as you are preparing your briefing. Now, the typical practice in patent trial and appeal board appeals of patent trial and appeal board proceedings is to designate the entire set of materials at the PTAB as the working appendix. And so that approach, is typically all of the papers and all of the exhibits. One of the things to consider is if you're the appellant and you don't need confidential materials to litigate your appeal, consider citing only to the public redacted versions of materials in your briefing. So for instance, let's say you're a patent owner. Let's say you presented a swear behind at the PTAB that relied on a bunch of confidential documents. But now on appeal, you're only going to be trying to distinguish over the prior art on its disclosure, and you're not pursuing the swear behind on appeal. One thing you could do is just cite all of your public redacted stuff, and that will save you some trouble down the line. One thing you should do, though, and this is based on some experience I've had, is if you do that, consider telling opposing counsel that you've done that, based on how things have developed to date, our brief only cites public redacted versions. To the extent that you'll be only litigating public issues, we encourage you to do the same. Obviously, we can't decide how you're going to litigate this. Maybe you'll rely on confidential documents, but to the extent you're not, you can save both of us a lot of trouble by simply citing the public redacted versions. And this actually this is based on some real life experience where I had an appeal. The proceedings at the PTAB did involve some sealed materials, but on appeal, we ultimately focused purely on public-facing issues, only to discover the night the appendix was due that the opposing counsel had actually block cited our entire confidential preliminary response. And we discovered this probably 6 p.m. The night, a midnight filing was due with the appendix. Eventually, everything got sorted out, but had we communicated that in advance, we could have probably avoided a lot of heartache and a lot of rushing around and a lot of printing things at the last minute. So communicate with opposing counsel. Maybe they'll take you up on it, maybe they won't, but I can guarantee you they won't if you don't suggest it. Give yourself a chance to encourage them to focus only on public materials if you're only litigating public issues as the appellant. Now, if you are going to be filing a brief or paper that includes confidential information, this is my pre-flight checklist for doing so. You have a couple extra tasks you have to perform. First, you actually have to prepare 2 different versions of the brief or other paper. You have to prepare a confidential version, and you have to prepare a non-confidential version. If you are doing this, if you are designating above a certain threshold of words as confidential, you actually will need to file a motion, a separate motion indicating why you need the additional confidentiality. You will then need to file both the confidential and the non-confidential version of the brief, and you will have to serve the confidential version either by mail or commercial carrier. You can also serve it by email if the parties agree to it in writing. One thing you should know, though, is that ECF will not serve confidential documents for you. You're going to have to do it yourself. And if you don't have agreement with the parties to serve it electronically, you're going to be shipping a big box of paper with the appendix. I'm sorry, with the brief or with the appendix. And that's something you need to keep in mind and be aware of. So I mentioned earlier that you've got a pretty low word count of confidentiality. And again, this is because the disputes before the Federal Circuit to an unusual degree reflect, there's a public interest in those proceedings to an unusual degree, not necessarily seen in private disputes involving non-patent matters. So that's why I think, and again, this is just spitballing, but this is why there's some pretty strict limits on confidentiality at the Federal Circuit in briefs. You can only mark as confidential up to 15 unique words, and numbers count as words, in the body of a paper. That's it. When you consider that you get 14,000 words for a principal brief, that's not a whole heck of a lot. So you need to be very precise with your claims of confidentiality. Now, if you repeat the same confidential material in a paper, that doesn't use up any additional of your unique word allotment. So let's say you're litigating secondary considerations and you're trying to show that your product is commercially successful to the tune of $25 million, but you want to keep and so you refer to, say, $25 million in the statement of the case, and then again in the body of your argument. That 25 million figure, sales figure, repeating that only counts once. It's just one unique word. But again, as you can see, you've got a very, very tight limit on that. If you are responding to a confidential brief, you don't lose words for including you don't lose words in your unique word allotment for words that were marked confidential in the other party's brief. So for instance, returning to that $25 million sales figure, if you are, filing a responsive brief to a principal brief that raises that, your use of the 25 million figure in your responsive brief doesn't actually count against your 15 unique word allotment because you're responding to material marked as confidential in the other brief. So as you can see, this is a pretty low word count. It's a tiny fraction of your brief. And again, this reflects the public interest in Federal Circuit Appeals and public interest in access to Federal Circuit Appeals in particular. So what do you want to do if you need more than 15 words as confidential? My advice would be, first, think about whether you really do need more than 15 unique words as confidential. If you are presenting legal arguments, if you're presenting factual arguments, oftentimes that's not going to be difficult to present that as confidential, especially if it's things like distinguishing over the prior art or making legal arguments about facts that aren't necessarily confidential. If you are going to pursue additional confidential words in your brief, you'll need to file a separate motion. The motion will need to develop good cause for why you should get more than 15 unique confidential words. And that means you need to show why those additional confidential words are necessary and why the confidentiality itself is necessary. So typically what that means is you can't develop the argument without the confidential material. That is really the standard that the Federal Circuit looks at, and that is the sort of standard they consider. This is in some of the practice notes to the Federal Circuit rules. You really need to have both a reason to rely on it and justify its confidentiality. That motion needs to be filed concurrently with the paper for which the 15 unique word limit is sought. So that's going to be the confidential version of your brief. And this is just filed as a typical motion using CM-ECF. Now, to actually prepare the confidential brief itself, you have a couple additional steps that would not occur in a brief that does not implicate confidential material. The first thing you need to do, include confidential in the title of the brief on the cover page, straightforward enough. The second thing you need to do is for each item that you are marking confidential, you need to highlight it or you need to enclose it in brackets. I recommend highlighting because it's not going to mess with any of your pagination. Make sure if you do that, you're not using the color you're highlighting the confidential words with for any other highlighting in your briefing. One approach is, use color text if you've got like a color-coded figure, for instance, and then use highlighted text to mark in a different color to mark anything that you're going to be indicating as confidential and redacting from your public redacted brief. Your brief must also include a certificate that indicates the exact number of unique words sought to be marked confidential. This goes back to your 15-word limit. And you can do this using Federal Circuit Form 31. It's available on the court's website. And there's essentially two types of certificates you'd file. One is when you're in compliance with the 15-word limit. The other is you're not in compliance with the 15-word limit, but there's a motion to waive the 15-word limit being filed concurrently with the confidential brief. So that's how you handle preparing a confidential brief. And this is, what you would file under seal with the Federal Circuit. You will also need to prepare a non-confidential brief, and there's some additional steps for that as well. First, you need to include non-confidential on the title of the brief on the cover page. Second, where you are putting redactions, these redactions need to correspond exactly with the material you've highlighted or bracketed in your confidential brief. And you need to also, on each page where that material is present, put a legend, I recommend top center, that says confidential material redacted. Make it big, make it clear, make it very obvious that there is stuff redacted from this page. One of the other things you will actually need to do, and I'll explain this more in detail on the next slide, is on top of the redaction, you have to provide an adequate general descriptor of the redacted material. And so that essentially identifies the nature of the redacted material without specifying the specific material to be redacted. So returning to our secondary considerations argument we discussed earlier, over $25 million, you'd put a redaction, and on top of the redaction, it would say dollar amount or sales figures or pick your choice. And this is required for every redaction, and it must be specific to every redaction. So it's not just something where you put redacted over it. You actually have to say what the thing is you're redacting at a high enough level to protect that public interest in knowing what's going on in the proceeding. Along those lines, at the end of the table of contents of your brief, you'll need to include a short paragraph that describes the general nature of the redactions. In other words, what is actually being redacted here. And again, this is just a high-level summary. This is, again, balancing public interest and knowing what's going on against parties' desire for confidentiality. And this paragraph actually has to address each redaction and each page that each redaction appears on. And in sufficient detail to, again, vindicate that public interest. There's an example in the Federal Circuit practice notes. I would encourage you to take a look at it. But essentially, the paragraph starts confidential material omitted, and then it goes in detail. On page 42, we redacted a dollar amount. On page 43, we redacted a chemical formula. And we will actually get to that 2 slides from now. What I'm showing you right now, though, is how to actually perform those redactions with the general descriptor overlaid using Adobe Acrobat Pro's redaction tool. What you will do here is select the material to be redacted, right-click it after you've put the redaction in using Adobe Acrobat Pro's redaction tool, right-click it for properties, select the overlay text button, and then type in the custom text you want to appear over it. You will need to do this for each redaction individually. It won't repeat automatically. So just make sure you've gone through and done that. And then after you've made all of your redactions, burn them in. And as you can see, this process can take a little bit of time. So again, give yourself extra time. I know I keep saying that, but really and truly, it's very important when you're handling confidential materials. Jumping back to the earlier discussion, this is an example of a paragraph that you would need to include at the end of your table of contents in your public redacted version. Again, it's a statement that there is confidential material omitted, and then it describes the particulars of what is being omitted in sufficient detail to vindicate the public's interest in knowing what's going on in the proceeding. So now that you've prepared your non-confidential version, and now that you've prepared your confidential versions, it's now time to file it. For the non-confidential version, you're going to use the typical non-confidential brief, appendix, or joinder event. That's the first row in the second screenshot that I'm showing here. But if you have a confidential version, you need to select the confidential brief, appendix, or joinder event. And it's very important that you select this event because if you don't, it'll show up on the public docket. And that's not something you want to be frantically calling a clerk's office the next morning to have to handle. So, go to the filing tab, go to brief, appendix, or joinder, select the confidential event, and select the appropriate service method, upload your PDFs, and remember, CMECF will not serve them for you. You will need to serve them separately, either in paper using mail or a commercial carrier, or if you have agreement with the other party electronically, you can use email, ShareFile, Axel, Box, whatever file sharing service of your choice. But you will need to arrange, have a written agreement with the other party saying you can serve confidential materials electronically. After you've done that, review the docket text, do your final review, and then submit. So there are also some, we've talked about briefs. There are also some additional steps that you will need to handle when your appendix includes or might include confidential information. One of the things you should do if you are the appellant is prepare your final appendix designations as soon as the reply brief is filed. ASAP, immediately, if not the same night, then the next morning. And the reason for that is you need to check to see if the final appendix designations include any confidential materials. Because if you do, if the final appendix does include additional confidential materials, there's some extra steps you're going to have to go through. You're going to have to prepare a confidential version. You're going to have to prepare a non-confidential version. You're going to have to file both. And then you are going to have to serve the confidential version separately, again, not through CMECF, because it will not serve confidential materials for you. So, as I mentioned, immediately, as soon as the reply brief is on file, start looking to see if the final designations are going to include confidential materials, confer with the other party as well to see if, their final designations are going to have any confidential materials. If there will not be any, congratulations, your life just got a lot easier. You can just file the appendix publicly as is. Things just got a lot simpler for you. If there are confidential materials, you're going to have to go through some of the additional steps I discussed, and we'll start with the process for preparing a confidential appendix. One of the first things you're going to need to do is to actually include the PTAB's protective order after the table of contents, but before any other materials, and that means before the final written decision. Now, don't worry, that will not mess up your appendix pagination because you're actually going to give it a separate set of Bates numbers, and that's going to be Roman numerals. Now, it's worth pointing out here, the PTAB doesn't often enter a standalone protective order. Typically, the process is a motion to seal that includes the PTAB's default protective order or a different one, and then the PTAB will eventually enter it without necessarily including the text of the protective order in it. So my advice is when you are including this, include enough motion to seal briefing, and enough of the PTAB's orders entering the default protective order to show that, yeah, there was a protective order entered. So you may have, and do that in chronological order. It may be something like motion to seal, which includes protective order, and then finally, PTAB entering the default protective order, its separate order of conduct on the proceeding. All of those get consecutive Bates numbers and Roman numerals, and all of that goes before the final written decision and anything else in the appendix, but after the table of contents. Similar to what you'd be doing for the brief, you will highlight or bracket material to be redacted from the public version. If there's an entire page, you also have the option of, instead of highlighting or bracketing an entire page, just including a slip sheet that says redacted. My preferred practice, just to keep everything aligned, is actually not to use that and to use full highlight the full page or bracket the whole page. It just makes things easier for me to keep track of, but that is an option available to you. The other thing to keep in mind is the appendix is not subject to the 15 unique word limit, so for briefs, so that makes your life a little bit easier as well. When you are preparing the non-confidential version of the appendix, the procedure is generally similar. Again, insert the PTAB's protective order after the table of contents, but before any other materials, and give it Roman numeral Bates numbers. Include non-confidential in the title of the appendix on the cover page. Each page with redactions has to bear a legend in the margins that says confidential material omitted. Do the same thing with general descriptors over the redacted material. And at the end of the table of contents, again, similar to the brief process, describe the general nature of the confidential material redacted from the non-confidential version. Now, as you can appreciate, this might be a little bit longer than the paragraphs you would use in your briefs, just because there may be more materials, there may be full pages. So, adjust accordingly. Don't necessarily just copy and paste what's in your briefing into the confidential material omitted paragraph in the appendix. And finally, filing a confidential appendix, very similar process to filing a confidential brief. Select the confidential brief appendix or joinder for your confidential version, file accordingly. Select the brief appendix or joinder for your non-confidential version, file accordingly. And again, make sure to serve the confidential appendix via either common carrier or U.S. Postal Service or electronically if there's agreement between the parties. Now you may be thinking, wow, that's a lot of stuff. I have had to do so much stuff just to handle confidential materials with this appendix and the briefs. And guess what? You're actually not done yet, because there is one more step you have to do, and this requires a little bit of advanced planning as well. And that is a certification of compliance with protective orders. Basically, this requires you to meet and confer with the other party to say, hey, are there any materials that were under seal at the PTAB or were subject to protective order at the PTAB that no longer need to be, or does everything need to stay under seal? If things no longer need to be under seal, then you need to actually agree with the other party about that and present that to the PTAB ASAP. And preferably, immediately upon, final appendix designations, or perhaps even earlier in the process if, ultimately you can agree on what's going to be used and what's not going to be used in the briefing. This certification is due the same day the joint appendix is due, and you file it as a certificate of compliance protective order. It doesn't have to be a long certification, but again, this is the sort of thing where it reflects the Federal Circuit's interest in providing access to proceedings involving just generally, and especially with patents. And this is a required component of the process. It's not something you can really just brush aside. So, be diligent about it, communicate with your opposing counsel about, what's going in the final appendix. Does anything need to be sealed? Does anything need to be unsealed? Keep that line of communication open, and you'll be in much better shape. So finally, there's one special case of confidential information. It doesn't always come up in patent trial and appeal board cases, but it does sometimes come up in other cases, and can come up in patent trial and appeal board cases in some instances, which is personally identifiable information. Parties are required to redact it, and that includes things like social security numbers and financial account numbers, things you would not want to see on a public docket generally. And if there Now, those are required to be redacted. It's not optional. It has to be redacted under Federal Circuit rules. The nice thing is, though, if a document only contains personally identifiable information to be redacted, but no other confidential information, you're exempt from some of the strictures of Federal Circuit Rule 25.1E. That rule imposes a few additional filing requirements, most notably the requirement for filing a non-confidential and a confidential version of a paper. So if it's only personally identifiable information, you can avoid having to go through that process. But before filing a brief that might include that information, even as redacted, ask yourself, do you really need this to litigate your appeal? And I suspect the answer is probably not. But who knows? Maybe you've got a financial account number showing that you wired payment to the PTAB in a timely fashion to beat a statutory bar, on mandamus, perhaps, because I don't think that's reviewable anymore after click to call. But home addresses, stuff like that. There are ways not to need this, and I would encourage you to find those ways not to need this information or not to have to rely on it in your briefing to save yourself some of the heartache of this process. So we've covered confidentiality, and as you can see, that is a topic that can take up quite a lot. The rest of today is going to be mostly more miscellaneous topics, as well as what you do after all the briefs are filed and after the panel has made its decision. We're actually going to start with a citation of supplemental authority. A citation of supplemental authority is just a short letter brief that you file with the clerk of court. The clerk of court is retired Colonel Peter Marksteiner, and you can file these after your briefing has concluded. You can even file them after oral argument. That said, you are limited to 350 words, and you also have to use those 350 words judiciously, identify the case, identify the principle it stands for, and identify with pinpoint citations how it's relevant to a contention advanced in one of the parties' briefs. Gone are the days where you can surprise opposing counsel with a new case at oral argument. And candidly, I have done this once myself with a case that had been decided right before oral argument. Get your citation of supplemental authority on file ASAP as soon as you become aware of it. If that's the night before oral argument, so be it. Bring hard copies of the case to the court, or notify opposing counsel about it if you're not arguing in person. You want to be on the up and up about this. And if the Federal Circuit asks, well, did you raise this case with opposing counsel at any point prior to this oral argument? And the answer to that question is no. You're not necessarily going to have a great time. So, make sure you're staying on top of current authority. And if all your briefs are in, raise it promptly. The citation of supplemental authority has its own event under letters and notices. I'm not going to spend a lot of time on the details of that process. It's very straightforward, rarely, if ever, implicates confidentiality because you're just talking about legal arguments. So again, straightforward process. You can actually also respond to notices of supplemental authority, and you do it the same way you write a letter to the clerk of court. There's no official deadline to respond, but any response must be made promptly under the Federal Circuit rules. My advice, try to respond within a week if you can, and certainly before oral argument if you've got one coming up in the next day or two. And you file it as a response to the original citation of supplemental authority. We're going to briefly discuss how to litigate after the panel decision, including petitioning for rehearing and potential Supreme Court proceedings. Petitioning for Supreme Court review. So to petition for panel rehearing, you have 30 days after the panel's initial decision, 45 days if the United States or its officer or agency is a party. I believe that counts also if the United States is an intervener. It's certainly been my experience that that's the case, but if anyone wants to correct me on that, by all means, jump in. My advice is if it's ambiguous, do the earlier deadline. A petition for panel rehearing is not unlike a petition for rehearing or request for rehearing at the PTAB. You need to focus on points of law or fact that the panel misapprehended or overlooked. It's relatively uncommon to see a panel rehearing petition freestanding. More frequently, they're combined with requests for en banc rehearing. That said, there is the occasional special case where the Federal Circuit really did misapprehend something, and you don't necessarily need to overturn precedent, or you don't necessarily have an exceptionally important issue such that panel rehearing may be warranted, even if en banc is not necessarily. So you have some specific components that have to be included in your petition for panel rehearing. You must use a white cover. You must use a certificate of interest, table of contents, table of authority, your statement of points or law, specifically identifying what's been overlooked or misapprehended. Your argument, you must include an addendum that includes the panel decision and any statutes, rules, or regulations that the court would need to address to decide your request for rehearing. And then you've got a typeface, type volume certification, and you've got a 3,900 word limit on that. Include your typical certificate of service as well, and give 3 paper copies to the court. My advice, find a printing vendor you know and like. Save yourself the trouble of that process. There are professionals out there who do nothing but printing briefs for appellate cases, and do binding as well. And unless you've got a really good dedicated in-house department, just use a vendor. If you are petitioning for en banc rehearing, this is rehearing by all of the judges of the Federal Circuit, not just the 3 that originally heard your case. There's some additional special steps you have to take. And this is true whether you're filing a petition just for en banc rehearing or a combined petition for panel and en banc rehearing. You have to identify contrary decisions of the Supreme Court or of the Federal Circuit, or you need to identify an exceptionally important issue to a precedent-setting question, or both. Both are also acceptable. That said, the Federal Circuit usually does discourage petitions for en banc rehearing if there's an affirmance without opinion under Rule 36, or it's a non-precedential opinion and the opinion's unanimous. If there's a dissenting opinion, but it's non-precedential, grayer area, you've got at least one vote for en banc rehearing in all probability. But other than that, if you've got a precedential opinion or certainly a precedential opinion with a dissenting opinion, you've got a better shot at en banc review. And like a petition for panel rehearing, you've got 30 days, 45 days if the United States is a party after the decision for which you're seeking review. So again, largely the same components as a petition for panel rehearing are required for the en banc petition or a combined en banc panel rehearing petition. The only additional component is that statement of points of law, the signed statement of counsel regarding contrary precedent or an exceptionally important issue that needs a precedential answer. Again, you're still limited to 3,900 words, and you need to furnish 18 paper copies to the court. And, again, my advice, find a vendor. If you want to talk to me afterwards about folks I've used, I'm happy to. But in-house binding printing, that can be more trouble than it's worth. It's often better just to leave that to professionals. And finally, the process for actually filing these in CM-ECF, go to the filing tab, go to rehearing and en banc petitions, select your party, select all of the forms of rehearing you're requesting, and in particular, if you're filing a combined petition for rehearing, select panel rehearing and en banc rehearing. Review your docket text, perform the final review, and click submit. And then don't forget your paper copies. Now, if a party files a petition for rehearing, the other party is not entitled as of right to file a response. In fact, a response is only allowed by court order. If the court does order one, you've got some similar requirements to the original petition. You still got 3,900 words. You still have to have your cover, certificates, tables, your argument, and your addendum. And but again, unless the court orders one, you do not get to file one as of right. Now, something else you can do after a panel proceeding is to actually stay the mandate, move to stay the mandate pending Supreme Court review or seeking Supreme Court review. There's really only one principal reason to do this in appeals of PTAB proceedings, and usually it is because you are a patent owner, you have some kind of pending application, and you are trying to forestall the application of patent owner estoppel arising from the final written decision and mandate from the Federal Circuit to the claims that you are prosecuting. If you're familiar with patent owner estoppel, if not, it's a form of estoppel that arises and prevents a party from taking any action inconsistent with a judgment of the Patent Trial and Appeal Board, including obtaining patentably indistinct claims. It functions similar to double patenting, except the claims that are used as the reference are actually the canceled claims in the PTAB proceeding. So again, if you're trying to forestall this after a Federal Circuit decision pending Supreme Court review, you should move to stay the mandate. This is really sort of the only time in which a remedial order of the Supreme Court would be necessary to correct something that happens at the Patent Office. If you're not in that scenario, you probably don't need to move to stay the mandate. Just file your petition for cert. On the subject of the petition for cert, if things don't go your way at the Federal Circuit, your next step is to file a petition for cert with the Supreme Court. The Supreme Court has some suggestions on things that are particularly cert-worthy, but understand it's a long shot regardless. Usually you need a circuit split, and within the Federal Circuit, usually that means you need to identify two mutually contradictory precedential opinions of the Federal Circuit. You need to identify some kind of deviation from Supreme Court authority, which tends to be the most popular route for appellants from the Federal Circuit, or an important question of first impression. That petition is due within 90 days after the entry of judgment. So that's either the original panel decision if you didn't seek rehearing, or a decision en banc or denial of en banc or panel rehearing if you sought rehearing. One thing to note is that you don't need to have petitioned for rehearing at the Federal Circuit to file a petition for cert. You can just go straight to the Supreme Court. With the last bit of time we've got, I want to cover some miscellaneous topics that can arise. Consolidated appeals are basically one appeal that involves multiple proceedings. Most typical use cases are an appeal and a cross appeal of the same proceeding at the PTAB, or appeals of multiple proceedings involving the same patent. Say there's 2 or 3 IPRs involved against the same patent. They all get appealed concurrently. Federal Circuit will then consolidate all of those into one appeal, and it keeps things a little more simple. The court may also consolidate appeals of proceedings involving related patents. Less likely to occur, but it does happen sometimes, and oftentimes that'll be the case where there's common issues to them. Say, for instance, whether they provide adequate written description and they all have a common specification, or whether there's a claim construction issue common to all of them. The nice thing about consolidated appeals is they have a single set of briefs and a single joint appendix. The one thing to keep in mind, though, is you need to list all of the case numbers in the cover page of your appeal. And you also need to identify the correct caption, especially if there are multiple opposing parties in those appeals. Say, for instance, you're a patent owner, you're appealing 2 IPR final written decisions, and one of the petitions is filed by one petitioner and the second one was filed by a different petitioner. They all get consolidated at once. So your caption is actually going to have 2 captions. One is you versus the first petitioner, and one is you versus the second petitioner. So some additional practice tips: you only need to file through documents through CM-ECF in the lead appeal after consolidation. In ordering things in the appendix, my advice is, all your final written decisions come first. Start with the lowest numbered proceeding, and then final written decisions from the next highest numbered proceedings. Then certified lists, again, in numerical proceeding order, and then everything from the lowest numbered proceeding, papers, then exhibits, and then the next lowest numbered proceeding, papers, then exhibits, and so forth. Your appendix may be a little bigger. If you can split your appendix volumes by proceeding, it helps, but it's not always going to be feasible. That will help you navigate the appendix later, but again, not always feasible. Turning to constitutional litigation, the PTAB is sort of running out of constitutional things to litigate. There was a big spate of constitutionality litigation involving application of IPRs to patents instead of jury trials, and then retroactive application of the AIA to patents issued before the AIA, Arthrex, appointments clause, appointments clause issues now that final written decisions are being done by an interim director, interim Commissioner Hirschfeld. So, there are still some issues, most of them of the appointments clause variety, and in particular with, is Commissioner Hirschfeld a principal officer? And if you are litigating a constitutional issue, you need to let the Federal Circuit know that so that they can tell the Attorney General of the United States that. And so the way you do that is, as soon as you know you're going to litigate the constitutional issue, and ideally concurrently with your docketing statement, you need to file a short letter that basically says, this brief involves the constitutionality of a statute, and mention Federal Rule of Appellate Procedure 44A by name, and request that the constitutional issue be certified to the Attorney General. Someone from the Department of Justice or the PTO Solicitor's Office will then, be notified of this and can intervene appropriately to defend the constitutionality of the statute. Usually it's someone from Main Justice, and when I say Main Justice, I mean Department of Justice, but sometimes you'll see USPTO solicitors show up as well. And again, you just need to give them a heads up so they have the opportunity to intervene in a timely fashion. Finally, in some circumstances, often involving constitutional litigation, you'll have multiple briefs that raise the same issue in related appeals. You need to notify the Federal Circuit of any duplicative content in related appeals. just drop a little footnote that says, hey, this section substantially repeats my briefing in another case, and just make sure you're identifying that for the Federal Circuit. The most typical scenario where this comes up is constitutional litigation, where a party has multiple appeals pending and they're all litigating the constitutionality the same way. Sometimes you'll also see it if there are related patents at issue and maybe there's a related claim construction or written description, something at issue. The appeals weren't consolidated, but the arguments are the same. And that's another scenario where you need to notify the court of the repetitive material. All right. And finally, just wanted to draw your attention to some further resources. These are some links available in the slide deck. I'd especially direct your attention to the common filing errors available on the Federal Circuit's website. It provides a great guide for what to do if there is an error and also how to avoid errors. With that, that concludes the presentation. I'm happy to take any questions, and thank you all so much for attending today. It's really great to have so many folks here. Oh, Ashley, I think you're still on mute.
I do that all the time. So thank you so much. And I think Frederick actually has a question. Is in chat. He said that a question regarding consolidation related appeals. If the clerk's office consolidates appeals by patent, but the duplicative briefing can best be avoided by consolidating appeals from different issues, should a motion be filed, and in which of the dockets or all of them?
So yeah, so if your appeals have not yet been consolidated and you think they should be, first step you need to do, meet and confer with opposing counsel, to determine whether it's going to be opposed or unopposed. And then secondly, you can actually, assuming you want to move forward with a motion, you can then move to actually consolidate the appeals. Understand though that you're not going to get additional word count in a consolidated appeal. You're only going to get, your 14,000 words in a principal brief. So if you think you're going to need extra word counts, or if there's distinct issues, think about maybe not consolidating the appeals. Just consider how it's going to affect you tactically and your ability to present the issues and deciding whether you want to consolidate appeals or not. Usually the Federal Circuit, though, will make that decision for you.
Thank you.
Any other questions? If not, thanks again, Kevin, and thanks everyone for attending, and have a great afternoon.
Oh, wait, I think got another question coming in. The difference between consolidated appeals and companion appeals, that's a great question. So a consolidated appeal is essentially multiple appeals that are condensed into a single appeal for purposes of briefing and argument. Companion appeals are actually separate sets of appeals that generally proceed on the same schedule. And that's the principal difference between them.